Howdy, and welcome to the White Hat Law Show with Warren Nord, where we cover a mix of current events, politics, and the law. Take it away, Warren.
Welcome to the White Hat Law Show. I'm Warren Nord with Nord Law. Today on the show, we'll be discussing probate. And here to talk to us about probate and what probate means is Chad Lampe. Chad works with me at Nord Law, and he handles all of our probate matters. Welcome to the show, Chad.
Thanks for having me.
So, I get this question a lot. What is probate exactly?
Probate would be an odd word. Basically, it deals mostly with stuff that happens after someone passes away. There is the other section of probate which handles guardianships. But I think the subject we'll be talking today is what is needed after somebody passes away and the processes that need to go through in court, in the probate court.
So, it's a separate set of courts?
Yes. There are some statutory probate courts. In Tarrant County, we have Probate Court 1, Probate Court 2. If you go out to Parker County, you just go to see the county judge. The county judge will handle everything but contested matters. So it depends on, usually the bigger jurisdictions have a statutory probate court. The smaller jurisdictions, a lot of times the county court will handle it.
Now, can any attorney I talk to handle probate matters?
Sure. It's just like any matter. You just need to study and learn. You don't need a special
That wasn't
license.
the right answer.
No?
Chad was supposed to say, only I can handle probate matters in the state of Texas. I'm the only attorney. Can you try that again?
Yes, only I. Anything about probate. All the other
That's
100,000
better. I like that
Texas
better.
lawyers.
That's better for Nord Law. So
Right.
Anyway, sorry.
It's not like a patent bar, or a federal bar where you have to have admittance. If you're a licensed attorney, then you can practice before the probate courts.
Okay. And so I get this question a lot, and I think we see it. Can I make my own will?
Yes and yes. You can legally write your own will as long as it's totally in your handwriting. If you go and type part of it and write part of it, then you're going to run into some issues. There's the classic case of the farmer being trapped under the tractor and pulling out his pocket knife and carving all to life in the side of the panel of the tractor, and that being admitted as a will. But generally, one should go see an attorney. There are many aspects that are, even just coming down to the execution portion of it that are required statutorily, that if you don't follow, then you end up not having a valid will.
So are there witnessing requirements?
Witnessing requirements, notary requirements, self-proving affidavits, things that can be done.
Okay, my eyes are glazing over when you say self-proving affidavit.
So a self-proving affidavit is the affidavit at the end of the document which will prevent later on the necessity of the witnesses who witnessed the will to come in and testify before the court, before the probate court.
So should people come away from this conversation thinking that I can do my own will, just like you can do your own patent, and you can file your own trademarks, and you can sue international corporations all on your own?
You can.
But it's not a good idea.
I'm sure you can do your own heart surgery, but I'm going to go see a heart surgery.
It's a good idea. And what's an advance directive?
Advanced directive, there's directive to physicians. So I guess there's a kind of an estate packet typically, and we're switching over from, the process to the estate plan.
I'm just asking random questions
Just
that I hear
asking
from
random
people.
questions.
Yeah.
So there's three areas the way I see it to probate. There's your estate planning side, there's your probate side, which is after death, and what's happening in the probate court, and there's a subsect, the guardianship side, which is sometimes necessary if somebody becomes incapacitated and they're unable to make decisions, either physically or mentally. So from the estate planning side with a general question, does everybody need a will? Yes, everyone needs a will. So there's the will, there's a medical power of attorney, there's a statutory durable power of attorney, there's directive of physicians, HIPAA release, declaration of guardian in the event of incapacity. All these are kind of go into a basic simple estate plan. Yes, all those documents are a simple estate plan. And what they handle is everything from you being in the hospital to your passing, releasing of your information. The directive to physician, for example, will be, do you want all measures to keep you alive, or do you want to be allowed to be comfortably passed? That's basic. That's making a very Reader's Digest version of that directive. But it's something to where the doctors can look at, hey, yes, this was Mr. Smith's will, as in this was his desire to be allowed to comfortably pass, or we want to keep them hooked up to every possible, measure to keep them alive for as long as possible.
Okay, so if we were talking about, estate planning is the things you do before you die to prepare for that eventual occurrence.
Right.
The probate of that estate occurs after the person has passed.
Correct. And that can occur with or without a will.
Because it can occur.
Because it can occur. So, even if there's a will poorly done, you can end up having to where in a relatively easy process to a more complicated, more expensive process of an intestacy to having to do an administration and doing mother may I to the court with everything. So that there's a few ways to handle probate. There's small estates affidavits, probating wills by muniment of title, which is my favorite word, or requesting letters testamentary. So there's a variety of things, and you can never really. People come in and say, "Hey, how do I avoid probate?" I want to avoid probate, like it's the black hole of the legal world. I'm sure there's worse places. People should not be scared of probate. They should understand it's part of the process. If everything is done right on the front end, it's not a painful process, relatively speaking, on the tail end to administer an estate, as long as there's a will. It's a lot more complicated when there's no will.
So when there's not a will, I guess there's an administration, right?
You're correct. You can have an independent or a dependent administration. And again, you have in those circumstances, you may have to file a bond. So that can be a threshold problem, is if somebody dies without a will and the person who is the beneficiary, they want to be appointed as administrator. Well, maybe their credit's not great. And the judge sets a $50 or $100 or $200,000 bond, and they can't get a bond. So these are some things that, in a will, you can waive the bond. You can name your executor, you waive bond, the requirements are a lot less. And so this little bit of investment, and it is a minuscule investment,
right?
Compared to the amount of time and effort and money that can be expended on the tail end by not having a will.
Yeah, I think that just one example might be helpful. Somebody dies without a will, then the court doesn't know if the kids that show up are all of the kids, or if there's a black sheep that the kids have excommunicated. And so the court
that
has
was a
to know
sailor,
that.
and there's a child out there that no one knew
Right.
about. So there could be heirship determination.
So that raises the cost.
Raises the cost, raises the time,
dramatically.
everything to get
So
done.
having a will means that we know who gets stuff.
And I want to say one of the biggest things about in our culture is children from a previous marriage is very common now. And there are rules of intestacy, so if on that second, third, fourth marriage and you finally pass away and there's children from previous marriage, and you figure, well, we're married, everything goes to my wife. Well, that's not the case if there's children from the previous marriage. And a lot of bad things can happen to where, because the children have an interest in the home, which the widow, in that case, is usually shocked to learn. And so that may result in other property having to be sold in order to accomplish some kind of deal if the widow desires to stay in the home. You can end up having kids that you really didn't want to give them anything. Now they have a part of the estate, and things can get real ugly real fast. So especially if you're on a
More
new
complex.
Marriage, or on a new marriage, if you have children from previous marriage, you need to have a will. Just bottom line.
So there's varying degrees of better have a will.
Correct.
And so, well, thank you for that overview. If you'll come back just a minute, we're going to have Stephanie Click on, who's state representative for Texas, and she's going to tell us about things that the state legislature is doing. So we'll come back to us in a minute.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
Thanks again for joining us. Continue our discussion about probate, and we're sliding over a little bit. We're going to have Stephanie Click join us. Stephanie is a state representative in the Northwestern Hills and surrounding area, and she does a fabulous job. She's a registered nurse. I guess that's redundant, and so she's an RN, and she keeps up with her hours. So I'm pleased to hear that. And she's also still very involved in the medical world in the state legislature. Stephanie, I hear this phrase DNR. What's a DNR?
A DNR is a do not resuscitate order from a physician.
And what does that mean?
What that means is that in the event that patient should need it, no CPR will be done on that patient.
No CPR. So it is really not a lot. If they require any help at all to stay alive, then tough beans. So that's the way it is. Okay. Now, We were talking earlier about advance directives. How do those interact with
Usually, patients will, in their advance directive, will spell out what it is that they want and do not want. Some patients that may have a terminal illness like cancer and know that their life is going to be very short may choose to reject any resuscitative efforts.
Okay. Now, the Texas State Legislature and some activists in the world identified a problem. Talk to us about that problem and what Texas state legislature did about that, or is doing about that.
We, working myself with some other Right to Life organizations, we're getting calls from families around the state that had a loved one in an end-of-life or near end-of-life situation. And physicians were writing do not resuscitate orders on the charts without having a discussion with the family or the patient. So there was no consent. So a bill that was passed, authored by Dr. Greg Bonin this last session, passed during the special session, and it became law on April 1.
Oh, so I feel safer now, I guess. Everybody in Texas is. So if a doctor thinks that somebody should not be resuscitated or that it's futile or something like that, and we hear about these situations every once in a while, what is the process, what is the legal process that occurs or should occur before a hospital decides to withdraw care or take some sort of action?
That is another section of the code, and that's section 166.046. And that is, you have a hospitalized patient, and a physician deems that life-sustaining treatment, which is more than just CPR, it could be a ventilator or dialysis, a whole complement of treatment, is no longer appropriate for that patient, and they want to withdraw that treatment. Under Texas law, a physician would have to refer that patient to a hospital ethics commission or committee, and they review that. Once they review it and make a determination, then the patient and family, if it is upheld to withdraw life-sustaining treatment, the patient and family have 10 days to move that patient to an alternate facility or physician.
Okay. And so is there an appeal process?
The appeal process of that would then go to a court of competent jurisdiction.
Okay, so if you found that the ethics committee came up with the wrong answer, you would have to be an injunction, right? They have to file a...
Probably, although the statute really does not spell that out. And it also doesn't spell out what would be a court of competent jurisdiction, whether that would be a district court or a probate court. So,
Well, a probate court's just a district court of a different...
right, but obviously not all areas have probate courts. I think there are only 13 counties in the state that have statutory probate courts.
I had to rescue a client from a mental hospital in the area once, and we filed just in district court habeas corpus. I felt like I was doing an ancient spell of some sort. But I suspect that any district court would probably be taking that. It's interesting.
You might be interested to know that some of the patients that called for assistance to some of the Right to Life organizations, and that we were able to get transferred to alternate facilities, some of those patients are still alive years later.
Scary stuff.
It is. It is scary stuff.
Now, I have to ask the question, is that normally people, because they don't come with money, they don't have insurance? Or what?
Not always. Not always, because we have had situations where someone was fully covered with insurance. It's a matter of wanting to turn beds in a lot of these facilities.
Well, that's weird. So what is a hospital required to do? I come in, I'm unconscious, or maybe I'm in and out. What is the hospital required to do, and I want to separate what they're required to do from best practices, which they may do all anyway, right? There's lots of things that people do without having a law to tell them what to do, just because it's best practice. What does a hospital ask for? What does it take? What does it require? And what are they required to ask for and take?
Do you mean upon admission?
Right.
Usually when you are admitted, and in fact my husband just recently had outpatient surgery, and they ask whether or not he had an advance directive.
Everybody has to sign their HIPAA release there for it. We'll get that later. Yeah. So
they ask him whether he had an advance directive, and if he did have one, if he would bring it to the facility when he had the procedure. If you do not have one, you're given information that you can complete one at the facility, but you're under no obligation to do so.
now, is that a law, or is that just best practices that most hospitals do?
I actually think it's federal law.
Federal law.
Yeah, I think it's federal law.
Let's check that out. We'll get our team right on that and see.
You frequently, when you go and visit a physician in their office the first time, they will also ask that question.
I think I'm asked that question often enough that, I think that's pretty familiar.
So what's the procedure typically if somebody comes in, just unconscious, car wreck, whatever, care flighted in, don't know who the family is? How do they go about making those decisions?
What they typically do in those cases is they will generally render care, and then they will go about trying to find next of kin, to make alternate decisions. But generally speaking, if they've got an injury that they can potentially recover for or be treated, they generally provide care.
Well, good. Well, as one of the 150 people in the state legislature, do you think that we've got our laws the way they need to be pretty much, or do you think they need to be changed in some way, or what would you say?
I still think that the 10-day process, I think patients and families need to make healthcare decisions. I think an ethics committee can still have some inherent conflicts of interest. Many of those are made up of employees of the hospital, which has its own sets of conflict of interest. The statute as it's currently written only says that the attending physician may not be a member of that ethics committee, although they are presenting their case facts to that committee. So I still think that there can be some reforms on that. A couple of sessions ago, I was involved in some reforms that would have eliminated nutrition and hydration. I have had situations where patients that the only life-sustaining treatment they needed was nutrition and hydration. And a hospital ethics committee voted to discontinue nutrition and hydration. And so we were able to get the law changed that nutrition and hydration is ordinary care now. There can be times when it's medically contraindicated to withhold those items. Somebody that's in renal failure, you have to restrict their fluids because of that. It would make their medical situation worse. So there are medical contraindications to that. But generally speaking, we're now treating nutrition and hydration as ordinary care unless the patient's advance directive rejects that.
Interesting. Well, that was fascinating. I bring these things up because these things, the kind of things that people come up and ask, they have real questions about. Everybody's going to face this at one time or another. And I've known people who've gone through the process. I know of one man who died a couple of years ago, and he had been the executor for both of his parents, and he didn't enjoy it, so he didn't have a will for himself. And his 5 kids from 2 different families had to figure it all out, and of course it was 3 times more expensive than it should have been. And so, and then of course you have these issues of, well, what does it mean if I'm going into the hospital and I'm in and out of consciousness, and someone's got to make a decision? The moral of the story is just about everything is better and cheaper if you think about it and plan just a little bit ahead. So,
a lot of people don't think in terms of needing a will, and I think in our family, as soon as the first child was born, the light came on. Oh, we need to be thinking about who will take care of our children in the event that we're not here to do it, and so forth. But we review our documents every year. Somebody that might be an alternate to the medical power of attorney may have passed away, and you may need to name someone else in those documents. So once you do them, don't think just done and never think about them again. You really need to review those periodically.
Sure.
Yeah, that's a great point. Yeah, we'll see stuff from the 80s and stuff. Yeah, can you check to make sure this is all right? And a lot of times there's gaps, or executors passed away, or all the kids have gone. So that's a great point. The fact that you're actually doing that is, not the norm. You're in the minority.
You're a 1%er.
You're a 1%.
And on your healthcare directives, your views on that can change too. Your health status may have changed. You may have recently gotten a diagnosis that you have a terminal condition, and what you ultimately want and how you want to be treated may have changed, and you might need to
Maybe
redo those
specific
documents.
conditions that suggest a nuance in what you already have is to fix things up. People wind up having each other as medical power of attorney, and then they get married and then they die in the same wreck, or they're both lots of things can happen. So I want to thank both of my guests today. Thank you, Stephanie Click, Chad Lampe. With that, we're going to wrap this up, and we hope that you join us again next time on White Hat Law.
Well, that's a wrap, folks, and we want to thank you for listening to the White Hat Law Show here with Warren Norrid. To find out more about Warren, check him out at norridlaw.com. See you next time.